115 application for upgradation, my lord. Any day fix up, my lord.
What is the application for? What
Yes.
is it for?
Dismiss for default. Can one
Restoration.
restoration?
Yes, upgrade it. Upgrade it. Monday, keep it at. Yes.
My lord, may I mention one matter?
Yes, yes.
My lord, case number is WPST 164 2024 with CAN 1 2025. My lord, in this matter, urgency is that the petitioner number 3 is presently highly critical condition and his survival in uncertain unless the interim relief aspirate for in CAN 1 2025 is granted by this honorable court. The petitioner number 1, being his mother, has been compelled to arrange the cost of surgery treatment of the petitioner.
What is pending in the writ petition?
My lord, the petitioner number 3 is a child, 4 years child. My senior is mentioned two
Yes,
times.
we have
Yes.
allowed this.
That's why, my lord, I am praying to that it can
We have allowed this. Check up what
Yes,
happened.
my lord.
Why it is not there?
It can be fixed, my lord, before
Yes.
vacation.
That should be mentioned one matter.
Much obliged, my lord.
My clerk mistakenly marked the original certified copy. I'm praying for liberty to file this application.
Yes. Yes, call them.
Item number 2.
Only blood, I'm led by learned Advocate General in this matter, Lord. I'm led by Advocate General in this matter, Lord. He's on legs in court number 8. But if your Lordship kindly takes up the matter on Monday, because today, my Lord, 2-volume petitions, he
Is
has
it
not,
all right?
he has not prepared himself. That's why, my Lord,
Only we have heard. Yes, just wait.
They should not enforce not the order of transfer in the meantime.
There is a transfer order.
But your lordship
But already,
no, no,
already given effect to whatever, my
But
Lord,
let them, if they want to proceed, I can proceed. Since they are paying for an accommodation on the ground of the learned advocate general, I have just pay for this interim arrangement. But the interim order passed by your lordship's court is at page 159. I'm sorry,
but my Lord may recall,
page 322.
my Lord may
Please
recall
have a
your
look at
Lordship's
322.
blood that affidavits, without affidavits, order was passed. Your Lordship did want.
So now the IA has finally been disposed of.
Yes.
Now please come to 322. That was the interim arrangement. Or not the observation expressed by your lordships at page 322.
Actually, my lord, it was on Wednesday. Wednesday, I have filed for 48 hours. So, my lord, it is.
We had said we will keep it on Monday. Why it has come today?
Yes, I'm deeply obliged, your
But
Lord.
the listing date was given Friday.
Maybe, but when you had mentioned and we had said it will come on Monday, then why it should come today? We had told you it will come on Monday.
Monday, but
Yes.
listing date was.
Whatever it is, when you have mentioned and we have fixed it for Monday, why it should come today? If you had not mentioned, then all right, whatever list date was given on the brief, it should be listed. But you made a motion, you didn't want to wait for 48 hours also. We said we'll keep it on Monday. Why it has come?
Maybe, my lord, the listing date was mentioned.
Therefore, I'm asking you, what should be done?
But if your lordships have posted it on
We have
Monday,
posted on Monday. It is better that it comes on Monday. It will come on the same position.
Same
It will be the first case in the morning.
same position.
After you had mentioned that by Friday I have to join. Therefore, I remember. Then you said, all right, Monday is all right. You had? Yes.
The listing date was.
I'm deeply obliged, your Lord.
Item number 3. Item number 3, my lord. Service. Served. Served. Now below the affidavit of services. Who's that? With the kind leave of my Leonard.
You are appearing. So please come.
Yes,
Yes,
let him place the case.
as you like.
Similar blessing for me, Millard. This is Millard again, Millard against a transfer order. But Millard, this time, Millard, this transfer is Millard of a Group D employee. Millard,
Yes, you had told us yesterday. Where is that bar in transfer? You
yes,
said there is
kindly
a
take
bar.
Millard two notifications, page 85 and 86.
And who is for the respondent?
Millard,
State.
we have served, yes. State. Millard, he was a Group D staff of Millard Integrated Child Development Scheme. So Millard run by the state government.
ICDS department or under the scheme?
No, department. Which is why Millard, we are coming from SAT, State Administrative Tribunal.
And another one, you said there are two.
86. Millard, 85 is one, 86 is the second one.
So between 83 and 96, there is no change according to you. That stipulation
Millard,
remains
there
the
is
same.
rather, Millard, one more condition is now imposed, Millard, in 86. Millard, initially at page 85,
96.
86. Millard, initially, Millard, in
No,
page 85.
Page 86, but order of 96.
Correct. Millard, in 1983, Millard, at page 85, Millard, the bar was that, Millard, it should be a commutable distance from the place of residence.
Usual place of
Yes.
residence.
Now, Millard, 3B at Millard, page 86, Millard deals with Group D employees, whereas Millard clause 4 at page 86 starts with a non-obstante clause, and 4B says, Millard, there is another thing, Millard, which is to be taken into account in case, Millard, both the
So
spouses
that is
of
nothing unique to D.
Correct.
That is a general
that
thing
was
that
absent in
that is
85.
there in all the service, and how much it is enforceable, we know. Yes.
Yes. Which was otherwise not there in 85. Now, Millard specifically.
So this
incorporated in 86.
3B is the main thing.
Yes. And Millard, I am transferred to Millard.
So you are for the state.
I am appearing for the state, my lord.
What is this Group D employee? You are sending him to North Bengal.
My lord, may I come back with instruction on Tuesday, my lord?
You may. Don't ask him to. Don't take any coercive action. Yes, take down. He is on which post?
Not to take any question.
He is on which post?
Millard Group D employee.
Please
Millard,
give.
Oh, Millard, this I tell your lordship. Peon.
Huh?
Peon, right? Peon.
Peon. Peon in which office?
Peon Millard now in Millard ICDS project at Dhania Khali,
Hugli.
transferred to Millard Shukhiya Pokri. Otherwise, Dhania Khali, Hugli.
Hugli. Can you point out from the impugned order whether his post has been mentioned?
Kindly do not pass any order, my lord, because I have not received any brief, my lord, till now. I have been engaged by the government.
Then kindly don't disturb him.
Lord, I will.
You can't have it both ways. Either you say you will not do anything, we can record, or we'll pass an interim order. He's a Group D employee. You are making him go all the way to North Bengal.
I
What
will
is
not
this?
stand in the way, my lord. I will come back I will come
You
back with
can come back whenever you want.
In the meantime, nothing will happen, my lord. But I do not give any undertaking, my lord.
Then we are not asking you. We were passing the order. You said please don't. So therefore we ask you. Interim order
I am not on that, my lord. I will come back on.
You are appearing in this matter. Yes.
68 is below the transfer order, which indicates below where I am posted now, where I am transferred now.
65 দেখো 68 রবি সাহা পোস্টিংটা আছে
The present petition.
issued therefore unless the release order is stayed my lord he can really now work
What did you say?
that the release order has been issued but he did not join unless the release order is stayed my lord he is in
No,
limbo.
it is ineffective. If they can take no coercive measure, then what difference does it make to you?
But this will be my lord wrongly interpreted.
No, why should it?
Well, the release order may be stayed.
We don't know whether he has complied with the release order.
No, we have not. We have
So
not.
therefore, it's better that whatever it is, it will stay as it is. We don't know whether he has joined. He will say that he has already been relieved. Once the relieving order is issued, that means he is relieved.
That's why unless that is stayed, my lord, he remains, my lord, in limbo. He is neither here nor there.
Post facto stay, what is it? A relieving order prior to issuance of the relieving order, a stay could have been granted.
But the
Once the transfer order has been followed up by a releasing order, then where is
my
the
lord, we
question?
kind of to stay that order. I'm asking for stay so that, my lord, he is not, my lord, forced to go there, or no further action is taken.
So therefore, we are saying the authorities will take no coercive measures to enforce.
তো ঠিক আছে, তুমি ওখানে জয়েন করো, আজকে তখন দেখা যাবে। You go and join them.
Item number 4.
Like this. Activity.
Certain?
And that is why the records were not used. The cancellation was carried to the tribunal without and branches was the participant the next day. We came to the I put that and ultimately with the help of the administration and we found the so far as the is concerned and we were directly take part in the selection process and our recruitment was guided by the
Oh, 97 one.
yes,
The 97 issue.
97 issue. Now we are beginning most of the arguments that my client has offered. My client has ever been with an order similar that arising out of the same advertisement in 1997. So that 2002, the patent was prepared and we are February 2002, this fact was never brought to the consider. Then arising out of the same selection or the same advertisement, first one was cancelled, second one under the same advertisement, as it is the same course, the recruitment was surveyed. Same course. Now that these people, this person, the candidates were successful, they were appointed. Under the same advertisement, same department, same post, persons were appointed and we were guided to the same recruitment.
So that 2002 is after you.
None of the candidates who had appeared for selection were appointed. Only the candidates who approached this honorable court. That is it.
So how these other two persons were appointed? How the other two persons were appointed? Yes, you said that you have.
I said that I saw the same advertisement on the relevant part of the candidates were appointed.
Apart from you.
Apart from us. First selection process, first selection to candidate.
No, so that means even their selection was cancelled.
Same advertisement. He said, I got to copy with her. I began at the liberty to hand over this copy with her.
How can you do it like that? What is the effect? What do you want to say? You will have to.
I want to say that one of public 1997 selection process was
We have understood. What we are failing to understand is how out of one advertisement there can be two recruitment processes.
I do not know
How is it possible that out of one advertisement there can be two selection processes?
that is a responsibility given by this is not the way to submit a document to the highest court of the state or at a particular division wise. But I have got this one. But I was genuinely the rest of the document. There must be a
response from my lawyers.
No, unless you state on affidavit, why should they be called upon? Yes, by Monday. Serve a copy on them on Monday, then. You are appearing for the, you are also appearing in this matter.
This new things, my lord, almost at the hearing is completed, my lord, complete, and he is supposed to give reply to this.
The defense side do not understand that it causes any unethics.
No,
Question of argument, sometimes I also in other matter I became nervous with the it's like a question they cannot I can be court. That these are the facts, which leads to the path of injustice. Whether I'm entitled and my
my
understanding.
lord, he is always entitled to do so, my lord, by way of appropriate application, he has got the knowledge,
I was expecting this clarity from his client because he is a state model employer. The state must not discriminate anything in a courier combat.
We don't know, you must specify the circumstances. Otherwise, it is slightly unusual that out of one advertisement, there'll be two recruitment process.
That is my assumption. I will take the responsibility. My client must take the responsibility.
That's what we are saying.
The pleading must be very specific, not vague. I was, my lord, also taken by surprise, but it is not his fault. His client has not accepted.
Then you file it within a week. Give him copy, we'll keep it after the holidays.
Yes.
so, my lord,
What can be done? It is not possible now. Next. Mr. So-and-so.
Any litigation, my lord, if judge do not have merit, my lord, at the hands of your lordship, because I know, my lord, whatever your lordship will do, it will ultimately serve the ultimately it leads to the path of justice.
Any one of us.
But we are changing judges, my lord, but at the same time, Robert Posner used to say, changing judges changes law.
and your lordship kindly, by consent of the partner, hard part.
I hardened part, হবে রে বাবা, মামুনের ছিল। No hardened part. All efforts ended in smoke.
Are you opposing?
No, never.
That is what
I do not.
consent of the parties.
Consent বলো না, conferred jurisdiction হবে না। Part heard, my lord. Your lordship heard the matter, my lord.
No, written notes of argument hasn't heard.
Item number 5.
Order.
6/9/23.
9/20.
Is there any provision in the railway for counting this period? This involves 79 to 89, about 10 years.
My lord, yes, my
89 you were regularized.
my lord, there are dates, some dates are admitted. First admitted date, 31st July 1971. Applicant joined as casual labor in
No,
Eastern.
therefore we are saying 71 you joined, 79 to 89 as gangman, then you were regularized. So this 79 to 89 is the period that you want to be calculated as qualifying service.
Fine.
So under which provision you are claiming this benefit?
Fine.
And was the benefit considered by any order by the authorities?
The authority, yes, my lord.
Is there a speaking order in this regard? Where is that? Please show us, please show us.
First speaking order, page 40. And another speaking order, page 54. Last speaking order, page 54. Page 54. My lord, second round litigation before the honorable tribunal. Page 54, my lord, second speaking order, page 54 to 55.
So page 54, it appears that some part of it has been allowed.
My lord, some part allowed, not that part.
50%.
No, that they calculated from 89. My lord, yeah,
Pursuant to this order, what happened?
pursuant to the order of the law.
No, pursuant to this speaking order,
And I challenge that order before the honorable tribunal. That is my.
why did you challenge it? There's a direction for recalculating.
No, my lord, that is my recalculating, but they, my lord, calculated from 89, not from 79.
Therefore, we are asking you, what did they do pursuant to this? Where is that order?
That speaking order for past page 54 and 55, last portion in result, all the appeal are allowed. Impugn judgment of Delhi High Court are set aside. Read petition filed by the applicant.
That is quotation of the Supreme Court judgment.
Thereafter, for the appropriate judgment, settlement calculation of the applicant will be recalculated and all necessary action will be taken for payment of the settlement
Correct.
due as admissible at the earliest.
So why did you challenge it? That's what we are saying.
I have challenged because of the fact they calculated from.
Where is that? There is nothing here that has been calculated from 89.
My lord, that is, my lord, impugn order, my lord, after page 151.
Huh?
After page 159, impugn order.
Which impugn order?
Impugn order passed by the honorable tribunal.
আরে বাবা তোর 89 থেকে যে ক্যালকুলেট করছে সেটা কোথায় দর্শক পত্র দেখা আগে
My lord, kindly look into page 41st career order.
Sir, this is speaking order of page 40. What is the date?
Page 40, my lord, first speaking order finally come to.
Why do you want to go back in history? 2017, authorities passed a speaking order. They have taken into consideration a judgment of the apex court, which says 50% of the service will be counted. They have directed to recalculate accordingly. You have challenged that order.
My lord, that 50% calculated from 89, my lord, 7.
Where is that? Where is that?
My lord, that calculation. Kindly come to page 158. Total service 33 years 7 months and less non-qualifying service 5 years 3 months.
158. What is the date of 158?
158. My lord, 31st July 2012.
What is this, sir?
Thereafter, my lord, page 158 and 159, along with 157, all are, mine, your lordship kindly look into page 154, 154, and it's just P5, the, my lord, 7 revised PPO, they also calculated, my lord, 1989, 154.
From 89, you retired when in 2012?
Yes.
So how many years did you serve? 23 years.
My lord,
Sir, 23. Am I wrong?
yes, but 23. But according to 23 years and by the 28 years according to.
So 23 years you served from after your regularization. You want addition of 10 years. They have decided you will get only 5. You say that has not been granted. Now see page 154 in the second employee's details. After 1, 2, 3, 4, fourth line in this second column, how many years does it say? 28.5 years.
28.5.
So they have counted. You are saying they have not counted.
According to me, 33 years.
That's a different thing, but that is no ground for challenging the order.
33 years according to my lord, if your lordship kindly have a look into the railway manual, my lord.
So therefore, you say you should the entire period should have been counted.
My lord, according to me, from 79.
79 to 89. That means all 10 years are to be counted.
My lord, all 10 years, they have counted only half of the 10 years, 5 years they have counted. They have counted only 5 years. Kindly have a look into the, my lord,
All right, show us what is your claim based on. Your claim is based on what? Why are you giving us that?
a person who is initially engaged by the railway is on a contract and is subsequently appointed to the same or another post in a substantive capacity without a break in service such contract period of service shall be treated like any other permanent service in the railway and be taken into account for calculating for the pensionary benefit subject to the condition laid down in this rule. Provided that Roman 1, the period of contract service during which the contract officer did not subscribe to the state railway provident fund shall count to the extent indicated above. If during such period the railway servant concerned did not any inflated rates of pay by reason of absence of any retirement benefit. If the railway servant concerned has subscribed to the state railway provident fund during a period of service, he shall have the option either, that is not the first rule.
Show us from any document that you are a contractual employee.
Here, my lord. First appointment, my lord.
No, come, see, don't go in unnecessary history. You are claiming between 79 to 89. We are not going to allow you to say everything beyond that. From 79, when you were contractual, show us.
Finally come to page 33. I joined as a casual worker.
We are asking you when you became contractual. You are relying upon a provision which says contract labor. So when you were appointed as contract, show us from any document that you have been treated as a contractual employee. Any document, one single document.
I have engaged as a casual.
Then why you are relying on a document for contractual employees?
Casual labor.
Sir, please, see, either you have worked out your case. This is not the place to work out your case. If you are relying on a document which is for contractual labor, then you must show that you are in a contractual capacity. We have seen that you are in casual. That's why we are asking you, when were you engaged as a contract employee?
Sorry, page 35, casual worker from 1970.
We are not concerned with casual. We are only concerned with the document that you are relying upon. Your right is founded on that document which says for contract employees. Now show us when you became a contractual employee.
My case is that first casual, thereafter decasualized in the year 79.
When you became a contractual employee to rely on that document, tell us.
I am not placed that rule regarding my lord contract. My lord.
What is this?
Mine, the lordship kindly pardon me, my lord. First, I joined in the service of casual worker.
See, you must work out your case. Merely loudly saying will not help you. You have to work out your case that what you want. By making loud submission, it will not become a acceptable submission. Yes. We have seen, in according to in our opinion, you were decasualized in 79. You were made to work against a permanent post from 79.
79?
Yes. So which is the provision which will apply to this fact? Tell us. Why are you repeating the same fact 10 times?
They have already paid 40.
Prepare yourself. Learned advocate for the petitioner is allowed time to prepare. You can't make out a case standing here. You have to do it before you come to court.
Item number 6.
Item number 6, my lord, I appear for the petitioner led by Mr. Bikash Ranjan Bhattacharya, my lord.
What is it?
My lord, it is a case, my lord, I would say.
Can
my
it
lord,
come after the holidays? Is there something to be done today or?
No, that is not there, but my lord, long time petitioners are waiting for appointment, my lord, long time.
Matter is pending.
That is-
Another, what is the date of filing?
Date of filing, my lord, it's quite a bit time, my lord. Affidavits are exchanged and
Let it come.
affidavit in reply may be taken on.
It will not be possible for us also to. Now, this side, it will not be
Agency,
possible.
my lord, to be very.
If there is anything else to be filed, you may. file.
Affidavit in reply, my lord, date of- that I am. Reply to the-
So that will complete the exchange of affidavits.
Only distinguishing the judgment of the. And there is no chance of appointment because the 24th is the last working day in the state government.
Or should we proceed on merit there?
No, that's why I'm beseeching your lordship. It is possible.
An adjournment simplistic only, otherwise the affidavit in reply. Other side of it.
But any date is given by lordship.
Item number 7. এই ফাইলগুলো এদিকে খালি তো মোবাইল রাখ সর্বক্ষণ মোবাইল রাখো তো ঠাকুর ওইদিকে
নামটা পড়তে
If the affidavits are complete in this matter, your lordship, I appear on behalf of the state in this matter. Yes, your lordship, all the affidavits are, pleadings are complete, your lordship. Yes, your lordship, on the last occasion also, they did appear. When the matter was heard for some time. Shiv Hirok Kumar Basu is the advocate and record. That file.
Petitioner.
Aishna Tej. Ishudev, তুমি বলবে।
Item number 8.
I'm appealing for the Public Service Commission in this matter.
Item number 8, I'm for the petitioner lordship led by Mr. Fito Sani. He's engaged into some another court, kindly paying for a short passover.
Impugned order is at 115.
Yeah, proceed. There are private respondents also.
Lordship,
No.
no private trust.
State and commission.
State and commission.
Lordship, kindly make it a short passover. He's engaged into some another court.
Every date you want an adjournment on the same ground. Last day also it was adjourned on the same ground.
Yes, my lord.
Regarding this matter.
Then you should have full instruction before you make a mention. Somebody gives you partial instruction, then how can you say? And you are appearing without a file.
Lordship, he wants to argue in this matter, but right now he's engaged into some another court. Kindly, Lordship, make it a short passover.
Go send for him. Send someone to get him.
Lordship, I have already filed my affidavit in opposition, Lordship. They have been handed over with the answer scripts, Lordship.
You filed an opposition.
We have filed in opposition, Lordship. She kindly see paragraph 8 of my opposition, Lordship. After verification, the commission found that 2 more marks had to be increased to her, but in that event also she will not qualify.
Oh, so you have reconsidered
Reconsidered, but still she is not qualifying.
even after adding the 2 marks.
After adding the 2 marks, there is a tie between two candidates. But
And
as
how
per
many
the-
vacancies? There were how many vacancies? This is for which post? Where is the advertisement?
ICDS supervisor female.
It is a post under the government.
Yes, Lordship. The civil court, Lordship.
8 of 2019.
Yes, Lordship. As per the full commission's decision, if there is a tie, the first preference has to be given the candidate who has secured more marks in the personality test. In that event, she will not be qualified, Lordship, even if we award 2 more marks to her.
No, but where is the, you say you have reconsidered and added additional mark. Where is this?
Page 8.
Your opposition.
Yes, paragraph 8, Lordship. তুমি আমারটা রিকনসিডার করেছো? কোনটা? কোন কোশ্চেন? সব কোশ্চেন? তারপরে আমি আসিনি? হাউ ক্যান ইট বি?
So this score of 276, it includes the personality test.
Yes, Lordship. Yes. My
So
Lord.
the personality test preceded this revision of marks.
Yes, Lordship.
It was already conducted prior to the
Yes, Lordship. Even we tried to consider her, but she is still not qualifying, Lordship. And this recommendation list has been sent.
What we are asking you is, this personality test, was it conducted after revision of marks or it was all?
Before.
Yes.
The probably, my lord, they have now gone through, my lord, the marks. My lord, my lord, I have challenged, my lord, 4 question. Out of 4 question, my lord, they have accepted that 2 question already we have given number to other candidate. If that is given, then also, my lord, I will come in the zone of consideration. Why, my lord? My lord, kindly go through, my lord, the marks division, my lord, of the question which I challenge. My lord, kindly came to, my lord, page number 41, my lord. But I have challenged, my lord, 4 question. 4H, question number 13, question number 9, and question number 3K.
Yes.
My lord, in paper 3,
All has been
Paper
completed.
3 has 9 and 13.
yes, my lord.
Yes.
And the 3, that the 4H, my lord.
Yes.
The marks division is 2 into 15. The marks is 4H is for 2. If that is considered, then my lord, I will get 276 thereafter, my lord. Question number 13. Kindly come page.
So what you are saying is they should have given marks for the other 2 questions also.
Other 3 questions.
2.
My lord, I have challenged 4 questions.
Yes, for 2 they have already given you the marks.
Yes, even if they give 2, then also I came in the zone of.
Have you seen the opposition?
Yes, your lordship. I see, my lord. They have mentioned in para 8
Yes.
that, my lord, they have added only 2 marks. But in one question they have added. Though they have said that they have given 2 marks in 2 marks in 2 questions.
Yes, for 4H you have been awarded a marks.
Yes, and other question.
And 3K, 9 and 13 you have not been awarded marks.
Yes.
As per their
After
position.
revision of.
Yes, my lord. But in the record, my lord, I will show that they themselves accept that my question is accepted through RTI application. My lord, I came to another questions and answer sheet of another person, and they have given marks to them. My lord. In my supplementary, my lord, kindly come to, my lord, my supplementary. Supplementary page number 24. And my lord, petition page number 91. Kindly, my lord, compare. My lord will get
After the
my lord answer.
opposition, we have filed the opposition, they have just filed the, I have
Sir, it
received
is
the
their
supplementary.
It is their documents through RTI in the process, my lord, of pendency of the.
How it can be possible after
In the pendency of the, my lord,
Without leave of court you can file a supplementary.
my lord, to bring some documents.
We are asking you without leave of court you
My
can
lord.
file. Then why did you file?
My lord, till date, my lord, I prepare, but it is not.
This.
These were not even by the learned tribunal, these papers.
My lord, it is their documents, my lord. PSC has given the answer, my lord, to.
Why did you not include it in the case?
My lord, in the pendency of the proceeding, I got the RTI reply, my lord.
During
After filing this petition, I made RTI application. In the pendency of this proceeding, I
Yes.
got the RTI reply, my lord.
There has to be an end. This cannot go on forever.
My lord, they have given marks to the other candidate, my lord. In mathematics, my lord, in what I have annexed, my lord, in my petition to other experts, my lord, who in that arena, my lord, they have given endorsement that this mathematics solution is correct.
Correct. So according to that, everyone comes with an expert,
No.
then they should be given marks.
That is annexed in my writ petition.
So
And
what
they
we are asking you is this permissible in a proceeding? Tell us the law. Yes, that it can be done. You get an expert an opinion and then according to that we should alter the marks.
Yes, my
Give
lord.
us, show us any law.
If, my lord, in my writ petition, I annex the same. And my lord, after filing this writ petition, my lord, I made RTI application and asked for documents from the PSC. PSC given a reply, and my lord give me the answer script of another person, and from that documents, my lord, it is evident that PSC given marks to that candidate, but same answer. But PSC is not given marks to me. And that is why, my lord, I prepare a supplementary document, supplementary affidavit. If my lord grant,
On the basis of same answer.
same answer. Same answer, petitioner is also given, and that person is given the same answer. Though she got the number, but the petitioner did not get.
This we should not have. Show us, file it.
কিছুই ছিল না। Different experts check question papers of different students. As per the model answer sheets, we have considered their grievances, Lordship.
My lord, see the first, my lord, see page number 4, my lord. This is an answer script given by the PSC to another person, my lord. And relevant page is 24.
Which question?
My lord, kindly come to page number 24 as well as petitioner page 91. The petitioner give answer that is in 91, page number 91.
What is the question number we are asking you? Can you tell us?
My lord, the question number is, my lord, my lord, 9, my lord.
At page 4, it is serial number 9.
Sorry, my lord.
At page 4, it is serial number 9.
Supplementary.
Yes.
My lord, no, page number at page, my lord, this is an answer script of another person, and my lord, at no, I'm sorry.
Please
my lord.
come to page 4, madam. Please
Yes,
have a look.
Yes, my lord. 9.
That is the.
And that is in the page number, my lord. Pardon
We
me.
are not concerned with the answer. And this is your answer script. Where is the same page of your answer script? The front page? At which page?
My lord, 68, my lord.
60?
68, my lord. But I'm 11 page, my lord, answer is 71. Sir, what am I confused? 29.
'91. No, she's only concerned with 91.
Yes.
I am saying. Part of answer. Sorry. What is at page 91?
My lord, 90, no, not 91, my lord, 71, my lord. Page number, really, page 68 is the my lord first page of the that question my lord paper 4 and 71 is the relevant portion my lord. My lord, bottom my lord 9.
71.
Yes, your lordship.
And in this it is 24.
24.
Yes, number. What is the question? Question number 9. What is this?
May I make one submission?
Yes, sir. Yes. First, see this one. This one, this one. Where next? Yes, we have seen it.
Yes, my lord. And this is one aspect, my lord. And another question is, my
What is
lord.
the question, madam? What is question 9?
My lord, question 9 is kindly, my lord. My lord, it is at page number, my lord.
Come to page 66.
66.
And what will be the answer? Forget about what they have written. You tell us. Assuming that 62.5% is correct, what will be the answer?
My lord, page number 72, the petitioner mentioned, my lord.
Page number?
Page number 71, continue with the page number 72. My lord, 72 top, my lord, she has mentioned, my lord.
What? What has she mentioned?
My lord, Meenak,
Yes.
my lord, Neha করেছে 73% and Meenakshi করেছে 62.5%. নেহা বেশি শতাংশ ঘরের কাজ করেছে। নেহা বেশি শতাংশ ঘরের কাজ করেছে। My lord,
No, what does that mean? Please, I cannot understand.
pardon me, my lord.
Yes.
My lord, it is written that the Neha has done, my lord, 73% and Meenakshi has done 62.5%. And Neha has done a more 62%, my lord, work in.
Don't interpret. What has she written? Tell us.
Neha has done 73%. And Meenakshi has done 62.5%. Neha Neha has done more percentage.
So is that the answer that the question is asking?
Yes, my lord. It is asked.
Please, before saying yes, please read.
Yes, my lord.
When we are asking you, please read before you say yes.
May I?
Yes.
During school hour, Neha finished 73% of her homework and Meenakshi completed 5/8 of her homework. Who must finish a greater percentage of homework? Who must?
Who must?
Yes. My lord,
Not who has.
who must? Neha.
Sir, madam, we are asking you. You are relying on this document you have got under RTI. The question is clear as daylight. They want to know who has to, not who has. The answer is who has. So that answer is obviously wrong. To that we will agree.
It is a mathematical question and my lord, petitioner has mentioned that Neha has done a more marks than.
That's not what they want to know, that who has. They want to know who has to do more.
Must finish. My lord, it is in past tense, my lord. Neha finished 73%, my lord.
You please read the second part of the question. You must have appeared in many such examinations.
Greater percentage of homework. My lord, out of these two, my lord, I have.
Please read the question.
Who must finish a greater.
Who must finish? Who has to finish a greater work now? Not who has finished the greater work. And she is saying who has finished a greater work. So that answer is obviously incorrect.
My lord, this is a mathematical question, my lord. If out of.
There is no scope for interpretation now. There is no scope for
Then the
interpretation.
question will not be correct, my lord.
Question is 100% correct. Question is 100% correct. Your answer is wrong. And you are comparing with another person who has given a wrong answer.
My lord, they have given 3 marks for.
They may have, so you will get a answer for a wrong marks.
But if my lord, this is a my lord.
So everyone should get a marks for the wrong answer. Can you show us any law? That is why the law is in such matters court should not
Well,
get
then,
into
my
it.
client
Leave it to
schedule-
the experts.
60, and my lord, that is why my prayer is to prepare a committee who can, my lord, give.
Re-examine everybody's answer books.
My lord, in my lord, similar cases, my lord, this court also parts, my lord, some orders.
May have, we don't know.
My lord, and my lord, page number, my lord, I have given.
We don't know whether in a case where where admittedly the petitioner has given a wrong answer, the court has set up a committee to evaluate.
My lord, my lord, court is my lord, expert of expert. My lord, there is no.
We are
doubt,
not
my
on
lord.
that. We are on
But my
the
lord,
answer that you claim marks for. It is evidently wrong.
My lord, as per my understanding, my lord, this is.
We
my lord,
don't know. Then we are at great difference with your understanding.
Yes, that may be, my
Yes.
lord. And
We don't know how to interpret it the other way.
my lord,
It is very difficult for us.
my lord, in mathematics, my lord, may I, my lord, to my lord.
Whatever you want to say after reading the question properly.
My lord, this
Don't
is
read as if you have to get that result only. You read the question as it is.
my lord, this is
The
a
question asks who has to do more work. So who has to do more work according to you? You tell us as a lawyer. One has done 72.
mathematics. my
No,
lord,
there is a question of expert. One has done 72, one has done 62. Who has more work to do?
my lord,
The one who has done 62. Very clear.
73, my lord.
Lord Counsel, you go through the question number 9,
Yes, your lordship.
not once, 3 times. Go through.
My lord, during the school hours, Neha finished 73.
You do not,
Pers-
you need not go through loudly. You go through. Thereafter, you give the reply.
My lord, Neha is done, my lord, more because 60.
That's what we are also saying. We are not on a difference on that. Neha has done more. So therefore, you know that Neha has done more. There is no question of anything being done by any expert. You know that Neha has done more. Now, what does the question ask? Does it ask who has done more?
Greater percentage of homework.
Please read, madam. This is not the way. What is this?
You are representing the commission.
Lordship,
You are representing the commission.
Public Service Commission.
Public service.
Lordship, generally, Public Service Commission does.
Have you gone through the question?
Yes, Lordship, I've seen.
What is the answer required?
Lordship, the model answer sheets is
What?
who must finish.
Hmm?
Who must finish.
Who
Who
must
has
finish?
to do more.
Who has to do?
Who has to do more.
It is clear.
in his
Yes.
home, in our home.
It's not who has completed more.
Who
Who
has-
has to do more.
And this supplementary affidavit, page number 24,
Lordship,
is of whom?
Lordship, supplementary affidavit, I have not checked, Lordship.
You must have received a copy.
Yes, Lordship, I have received a copy, but this is of a
Just
different
now you have
candidate.
provided.
Generally,
Come
PSC
back.
does not provide any revaluation, but as they have alleged these allegations, it has been tallied with the model answer scripts. They have found that expert has given less marks.
So under
It has been-
RTI, you will give the answer book of anyone to anyone.
Lordship, I think it was given by order of the court, Lordship. By direction of the court, it has been given. We don't give it to anyone.
Where is that order? How you have got it? Where is your RTI application? Where is your RTI application?
That I have to, my lord, bring on record. देखो दिए चलो बता देखो
they are
Where is your
challenging,
application?
challenging the order of the tribunal.
Where is your
Not to be-
RTI
not
application?
even there.
Presently, it is not with me, my lord. I can ask to my client, my lord.
You bring it with that.
And my lord, another question, my lord, in tribunal given order, my lord.
Hmm?
In respect of question number 3K, tribunal
First, show us. We don't know how the commission has given an answer book of another candidate to you. So we are doubting your petitioner's assertion that he has got it under
I
RTI.
will bring on record, my
So
lord.
therefore, we are being very clear. We are asking you to say it on affidavit.
Yes,
Where
yes.
is that application under RTI and where is the reply?
Yes, I will bring my.
Yes.
And my lord, it is my lord not in this my lord proceedings, my lord. My lord, in normal cases, my lord, in public employment, my lord, if anyone asks for, my lord, it is given, my lord. In other cases also.
In
My lord, though my lord, I will bring for my lord has asked, my lord, definitely I will bring the documents for it.
they will give you the answer book of the other
Yes,
person.
my lord. Yes, my lord, given it because my lord, this is in public.
You have the RTI with you.
My lord, at present, my lord, I
Act.
yes, my lord, RTI Act. My lord, in soft copy. RTI
You give other person's answer book to the.
So generally it is not, I shall take instruction how she has procured
No, we
this.
are not accepting it. We are not accepting it unless she comes with the application.
Yes, my lord, I will bring, my lord. Give me, my lord, 7 days, my lord, I will bring.
I can ask for my answer sheets, but not anyone else's.
বসে থাকে আজকে আসেনি পড়ানা পড়বি না তো পেলো কি করে দিয়েছিল দেখ না দেখ
A supplementary affidavit is filed Hey, how she has got the answer book?
Sorry.
List after
The
1 week.
matter will come on.
1 week is enough.
Yes, 1 week.
List after 1 week.
Photo এটা কি দাঁড়া এক মিনিট কি বলতে চাই
You can also file your response to the supplementary.
supplementary
In the meantime,
can it
in the
between-
meantime, the learned advocate
Nine.
I brought the petition আমাদের last petition you will just ঠিক আছে আমি দর্শককে দিয়েছিলাম ওই জন্য অর্ডার লিখেছি কপি আটকে দিয়ে দিচ্ছে
I am appearing for the state respondent. May I be permitted to file my affidavit in opposition? My lord, I have not received the affidavit in reply, my lord. Can it be? I have requested my learned friend, my lord, to permission. Yes, opposition served. My learned friend, my lord, filed a affidavit in reply. No copy has been served on me. That is why I am requesting my learned friend, my lord. 1 day accommodation, my lord, or any day subject to your lordship's kind convenience.
opposition
Item 10.
And I for the petition.
Where is the charge memo?
I got page number. Page number 110, my lord.
110.
My lord. At page number 114, the charges are stated here.
And where is the inquiry report? And where is notice of disagreement?
My lord, there is notice of disagreement. In that reply in the CAT, there is a, they have that note of disagreement. Look at page number 53.
53 of?
I don't know. In paper book, 52, my lord. And here is also 130.
You have filed paper books? You have filed paper book?
My lord, as directed by lord, find the paper book.
Wait. Where is the paper book?
Supply of copy.
Oh, here it is. Oh, it is here. Yes, we have it. So from the paper book, can you show us the charge memo?
Only the reply and rejoinder is there, my lord. With regard to that for informal paper book is furnished.
Is the charge memo in the paper book?
No,
All right. Points of disagreement is there in the paper book.
my lord.
Which page?
Page number 52. 50.
50?
Original.
This petitioner was also participating. So I was in the bank, so check with an this office that whatever he has taken advice. In the very few witnesses I have appeared. None of them supported me. One said he heard the I was inside the chamber. W1. He expired. He is not particular. I was inside the chamber of the senior team. He does not charge. EW. Then they have not supported. Disagreement is proceed prosecution will not be authenticity of RUD has not been proved.
What is RUD? What is RUD?
In the charge sheet, made application 106, 116. 116.
Yes.
One,
116.
116, my lord.
We
Not
are,
appeared before the inquiry, my
we are asking you what is RUD?
RUD, relied upon document, my lord.
Oh.
Relied upon document. My lord, charges against his sprain. None of these officers has been called in the inquiry, my lord.
Where is the deposition of PW3?
Inquiry report.
Yes, from that we are asking you from that. What is the name of PW3?
PW
Shantanu Sinha.
Shantanu Sinha.
Where is his statement?
Inquiry proceeding. Letter page number 124. PW3 Shantanu Sinha. Page number 130, my God.
144.
130, 130, my God. Correct, BIT.
What does it say? That is at page 52 of the paperwork. Disciplinary authority has recorded the court. Court. I've given a statement of the matter saying, however, I have said which is that is not. Yes, sir. How do you sustain the page 52 of the paper book? And what is the final order passed by the disciplinary authority? Which page?
182.
182.
My lord,
It's not in the paper book.
not in, no, my lord, it is in the,
Then why you have filed a paper book?
But only for, my lord, directed to submit only the reply and rejoinder.
By paper book.
Yes.
Speaking of. This is the order passed by the disciplinary authority.
Final report. Final order.
Final order.
180.
2 lines, you are guilty. And where's the revisional order?
My lord, 193 page number.
Is the order.
194.
190.
Not a speaking order. One. Yes.
Moreover, my lord, this case proceeded on the 2 ways, my lord. On the on-site administration has taken through their own process, and they have filed the complaint before the court of law. That court of law has given me, acquitted me. I and Mr. J.P. Singh. J.P. Singh got all the benefits, my lord.
Who are you?
And I'm the J.P. Singh, my lord. J.P. Majumdar.
You are saying I and JP Singh.
No.
Jitendra Prasad Singh.
Yes. Come, take down.
Item number 1.
I am for the respondent.
I prefer the petition. 103. Yes.
We are allowing the
Grateful, my
You seem surprised.
Can we see
Not right now. There is some,
afterwards?
you will get it most probably today by evening. There is some minor corrections.
Yes. Because I have lost not so many cases. Regarding the recovery. That's
Gaining or losing is immaterial.
no. That is not depend upon the merits of the case. Not yes, certainly not. I will know. But this
Obliged, my
Item number 11.
My lord, 11 and 12 land user matter. All the matters have been fixed in the month of November. My lord, exact date copy date is 10th of November. 10th of November. 10th of November, my lord has fixed.
Numbers which you have given us in the other case
My lord,
and recording both the diary numbers, same order is being passed in all the cases.
grateful, man.
11 and 12.
11 and 12.
Please give your appearances.
Yes, yes, man. My junior is grateful, man.
Item number 13.
Now, this is my opinion of opposition. Loss 11. Opposition. No, this is my opinion of opposition.
Filing opposition.
The death took place on 11th of May 2003.
Mr. Mukherjee, learned AGP.
Hmm. 14.
Yes, sir, you are for?
item number 14, I am for the petitioner, my lord.
Petitioner. Yes. So what do you have to say?
Huh? I'm led by Mr. Partho Saudi, sir. Senior.
You have the file. You have the file.
Yes.
Let us see what is the order.
হ্যাঁ
রেজিগনেশন কিছু নেই দেখাবো বলে তো ঠিক আছে আসুন তোমারটা নাম কোনটা What? Division will be so wide. Connecting method. Bunch of methods. Lord, your lordship will kindly recall that when this matter was taken up on the last occasion, while your lordship was sitting with my lord Mr. Justice Partho Saruthi Chatterjee, your lordship was pleased to observe that that to find out judgments, that whether if a selection is vitiated, whether the tainted candidates can be segregated from the non-tainted candidates. This was the question, my lord, or this was the observation of the court. I just in brief, my lord, in within 5 minutes, I indicate to my lords. Lordship had already taken note of it, therefore I did not trouble. Notification was published on 23/12/2015. Then, my lord,
After this
16,
noti-
not 15.
23, 12, 20, 2016, 2016. Yes. Milord, then then Milord, the call letter was for written examination was issued. Written test conducted on 29/5/2016. Then result was published. Milord, that my lords will be pleased to find from page 52 to 53. Merit list was published. That my lords will be pleased to find from 54 to 66. Then Milord,
Cancelled on 12th
no,
February 18.
on 17/4, only one thing I would indicate to my lords. On 17th of April 2017, the assistant director issued a letter indicating that the result which was published on 17/4/2017 be kept in abeyance. That my
417 also a result was
Milord,
published.
I say Milord, kindly see page 69. Page 69 for a second. বলছি তো রে, আমাকে বলে দিস কিন্তু বল। ভুলে কিন্তু বলে দিস কিন্তু। Page 69.
No, this is not a result. This is
Milord an order.
keeping it up, keeping the 23/12/16 result in abeyance.
Yes.
Result is only one.
Yes.
23/12/16.
Yes.
This is
That is the
abeyance.
result.
Cancellation on 12th February 18.
Yes.
And then, of course, CAT and High Court, and thereafter untainted list published on 16/4/21.
Your lordships have taken note of the fact. I need not
Yes.
trouble my lords.
Yes.
Now, my lord, what I will be now submitting before my lords, that my lord, lordship may kindly my lord come to page 74 to 91. This is the order, my lord, which was passed on 11th of September 2019. Now, my lord, your lordships may kindly consider from my lord, I just the first paragraph or the second paragraph, not the first, second paragraph, my lord, deals with the facts. Then, my lord, I say, my lord, the paragraph 3, page 75.
Yes.
The reason for cancellation of the examination, as could be gathered from the communication dated 8th of March 2018, addressed to the Superintendent of Police by the Assistant Director of Postal Service, CPMG West Bengal Circle, Gojdas. Then, my lord, yes. Then, my lord, the irregularities in the particular process had been indicated at page 76. Then, my lord, I find that in the your lordships may kindly for a second, my lord, come to page 77. That
How to read page 76? That is the issue.
page 76. Page, my lord, I with a folded hands I say, my lord,
Yes.
I am also, my lord, I am put also to the same position.
Therefore, we asked
as
you
my
how to
man.
read.
My lord, I say, my lord, I have nothing more to say.
Yes.
Nothing to add. I cannot add anything.
Yes.
Then I cannot walk in the corridor. Then, my lord, I just draw to my lord's kind attention at page 77, the last paragraph. In view of the lapses on the part of the agency, the committee has observed the irregularities in the in the selection, in the OMR sheets of the successful candidates, as well as in the papers of those who failed to qualify. Out of 43 candidates, 438 candidates selected, 46 were not actually fit in a small sample of 53 non-selected candidates. 6 had similar lapses. This indicates that the whole examination was vitiated, and thus the committee concluded that the examination
was not conducted in a free and fair and partial manner. So it has finally recommended for cancellation of recruitment and initiation of a fresh recruitment process. Accordingly, the examination dated 29/5/2016 and result thereof declared on 23/12/2016 has been cancelled on 12th of February 2018 as per the order of the competent authority. Then, my lord, kindly consider. ঠিক আছে তো?
Where is the High Court's order?
Yes, Miller, I am showing to my lord, Miller. Miller, challenging this order dated Miller 12th of February 2018, a writ petition was filed, and that writ petition is dated 11th of September 2019. That my lords will be pleased to find from Miller page 139. Yes. ঠিক আছে, হ্যাঁ 139 page. Then I start from the page 140.
So what you are reading from the CAT's order has been quoted at page 141, perhaps, on
Yes.
careful consideration.
Yes.
Second
On
par-
careful consideration. Yes. On careful consideration of the contentions on either side in the light of the materials brought on record, including the relevant portions of the vigilant investigation report for inquiring into the irregularities, if any, in the selection process of the candidates does not support the stand taken by the writ petitioners in deciding cancellation of the entire selection process for the post of postman and mail guard. It appears that there has been no serious grievance of any malpractice as such in the selection process method of selection by those who actually conducted the said selection process. We hasten to add that it has been finding of the vigilance report that out of 438 candidates qualified, 46 were found unfit, and on sample study of 51 non-qualified candidates, 6 had lapses. Therefore, there was no infirmity in the selection of untainted candidates. In the light of the above, it can be inferred that there has been no concrete and relevant materials which shows widespread infirmities of all pervasive nature, which could be really said to have undermined the very process itself in its entirety or as a whole, and it was impossible to weed out the beneficiaries of the other irregularities and illegalities. It is well settled principle enunciated by the apex court that in connection with the selection process, if it is possible to weed out beneficiaries of illegalities and irregularities, the same should be carried out to bring the selection process into logical conclusion. In the light of the above findings by us, we feel opposite to rely upon the decision of the judgment of the apex court reported in 2003 volume 7 SCC 285. On a careful consideration of the contentions on either side, Miller, this particular quotation has been of this particular judgment of the Supreme Court. I have also brought this, I will show to my lords. Then, my lord, the court ultimately gives observations at page 144. It is also not disputed by the writ petitioners, and possibly in a given situation like this, the segregation would be the best possible method so as to ensure that the candidates who have successfully participated in the examination process are not deprived. The vigilance report also goes to show that out of the samples of 51 qualified candidates, 6 had lapses. The learned counsel for the writ petitioners on instruction has submitted that the entire exercise can be completed by the Postmaster General, West Bengal Circle, within a period of 3 months from the date of segregation of tainted candidates. Accordingly, we dispose of this writ petition by directing the Chief Postmaster General to complete that such exercise within the period of 4 months from date and publish a list of successful untainted candidates in website and issue appointment letters after the exercise is complete.
So you are agreed by the consequence of the result taken.
Yes, yes. Now, my lord, I want to show another thing to my lords, that your lordships may kindly take note of that. This was the matter, my lord, which on the last occasion your lordships had taken note of, that the vigilance inquiry report that would be found from page 121 to 138. That is annexure P10. Because your lordship, my lord, wanted to ascertain from me what was the vigilance investigation report I had shown. Now, significant feature of the matter, my lord, which comes to, my lord, it boils down to the same thing as to whether the tainted category candidates can be segregated from the non-tainted category candidates. Because I find from the judgments of the Supreme Court, there are two views. As an officer of the court, I should, my lord, draw it to the attention of the court. One view is that if it is being found that irregularities or the particular process of selection has not been done in the manner it ought to have been done, then the court, my lord, cancels the selection process and directs for de novo selection, permitting the candidates to appear, and in the cases where it is found that the candidates have crossed the age limit, there, my lord, a relaxation is given that after condoning the age, they should be permitted to appear afresh.
Where weeding out is not possible.
Yes. I say why? Because I say, my lord, that the tainted category candidates belong to a particular group. The non-tainted candidates also belong to a particular group. Now, a person cannot be faulted for a wrong or for the action of the wrongdoers. Because I appear in an examination fairly, and a counterpart, my lord, appears in an examination not fairly, or he has been favored by some persons, my lord, or at the dictation and machination of some persons, he appears. And ultimately it is found that there has been an irregularity. Then normally, my lords have laid down the law. My lord, this I should show, and then I leave it to my lord's kind consideration. My lord, just, my lord, kindly permit me, 2014 volume.
Can we, before that, what we have to see is now, can we come to a conclusion contrary to the High Court's decision earlier? The decision to undertake a weeding out exercise
Yes,
is already final and binding in view of the earlier order passed by the High Court.
yes,
So now that issue is not before us.
yes.
It is now the only consequential action taken as a result of the order passed by the High Court in the earlier proceedings that at best we can see.
That
I cannot now go back to examine whether there is any occasion for conducting a weeding
No,
out exercise or not.
Milord, I was only indicating to my lords, your lordships may kindly take the pains, Milord, to come to a particular conclusion as to whether, Milord, the order which was passed by the High Court in the earlier occasion. High Court passed certain directions that your lordships have taken note of it.
Yes.
ওটা কত পাতায় ছিল?
So weeding out, it's at page 144.
Yes, yes. Milord,
That
just
weeding out exercise has been directed. It has to be done.
Yes, 144. I'm grateful to my lord. Now, after this order was passed, then this order was passed, my lord, kindly consider the dates because this date is very relevant, my lord. This was passed on 25/8/2020. 25/8/2020, this weeding out.
25/8/22 cannot be.
My lord, I find from my brief, I do not know, page 139.
2020, yes.
Yes, 2020, 25/8/2020.
I wrongly heard 22.
No. And this order, which is now the subject matter of challenge before my lords, this was passed on 29/2/2024. The order
Correct.
impugned.
So, as a consequence of the High Court direction, the list was published on 16/4/21.
Yes.
Now 16/4/21 list was assailed by you before the tribunal.
Yes.
So therefore, can we now look into whether there is an occasion for?
No, I say, my lord, that supposing, my lord, your lordship knows, my lord, that there are judgments galore that if a particular thing is directed to be done in a particular way, it must be done in that way and in no other way. Now, this particular, my lord, list, as your lordship was indicating, whether these list can be, my lord, because there is a list of, your lordships may kindly consider from page 138, 148, I stand wrong, my lord, list of untainted successful candidates.
Yes.
And thereafter, এটাই তো ইয়েটা তো লিস্ট অফ আনটেন্টেড সাকসেসফুল ক্যান্ডিডেট টেন্টেডটা দেখা কত পাতায় টেন্টেডটা একটু বলবি
Have a look at the. It has said.
কত পাতায় আছে একটু বলবি
Can you please point out where the vigilance report was? Which page the vigilance report is?
Yes, my lord, I'm just vigilance, your lordship wants the vigilance report.
Yes, just
Vigilance report is
122.
121 to 130. 122, actually, the kindly also see the date of the vigilance inquiry report. This is 9/2/2018. Therefore, prior to the, as your lordship was indicating. Category. Tainted list, এটা তো হচ্ছে কি untainted. Tainted list কোথায়? দেয়নি কেন দেয়নি বলতো যদি আমার নাম
The boy, son, this son, or we have
এই প্যারাগ্রাফটা দেখুন এই প্যারাগ্রাফ 8.5 দেখ 4.3 পেজ 4. Yes. আচ্ছা এখানে
29.5 exam.
Incomplete. Milord, I'm grateful to my learned juniors. Milord, page. Kindly see the order of the order impugned or the order challenged in the present writ petition. This is internal page 7.
Yes, we had seen that. We thought
Yes.
you wanted to refer to something else.
Yes, I wanted to show to my lords that so far as my name is concerned, that is at internal page 8, Rinku, at the first name. The reason is
There is only one
incomplete
petitioner.
declaration. Milord,
There is one petitioner.
I say, Milord, there are, Milord, so far as this petition is concerned, Milord, I say, Milord, okay? Yeah, I find, Milord, so far as this petition is concerned, there are 7 applicants.
So they are all in this
Yes,
list.
and your lordship directed at the bunch because there are similar bunch of matters.
So they are all listed.
Yes,
How many? How many?
I do not. I coordinate.
Item number 15.
15. So, but the issue is one and the same.
And what's the submissions made by
You are appearing in some cases.
item number 15?
Oh, you are in 15. So there are only 2 cases.
Then I Joseph.
I'm appearing in 14 and 15, 2 matters
You are for
for the respondents.
in both the matters.
In 14 and 15, ষোলোতেও আছে? নেই, নেই।
Only 2.
There are 2 listed. Whether there are more matters, we are not aware of. Apparently, my instructions are there are total 5 matters.
Total 5.
5 matters covering the same issue.
But today there are on list how many? 2 only.
Only 2.
So obviously you are not appearing in the other 3. Otherwise, yes.
Now, one thing I should also show to my lords that paragraph 8.5 of the internal of the order, the submission of the applicant, that once the applicant's name figured in the list of successful candidates and untainted candidates, I find, Milord, that this is because there is no reason as to why I can be held to be a tainted candidate. Because insofar as my name is concerned, Rinku, this is incomplete declaration.
This is
Incomplete declaration. That my lord will find from page 8 of the order. The first name Rinku, unsuccessful, incomplete declaration.
that declaration was to be given in handwriting,
In the poem.
and that also in a particular
Is
ink.
also incomplete.
Huh?
Lordship, there are 3, just pausing for a moment. Lordship, item numbers 21, 23 and 24 relate to the same issue.
আচ্ছা, তো লিস্টে আছে?
না সেটা লিস্টে আজকে আছে
আজকের
সেটা আমি জানি না।
21, 23 and 24.
So who is appearing in these matters?
They should be all should be hard, but I principally I what is my submission I conclude because I know that because after your lordships gave that hint just found out. My lord, I found out three judgments. My lord, I first, my lord, I am told, my lord, I am being instructed by my learned junior that all 7 of this petition, their results are incomplete.
They are all in the same category.
Same category. Therefore, they cannot be categorized as tainted category candidates.
See, now this matter has come through 3 forums, twice the CAT, once the High Court. We don't know why they have been called tainted.
That's the thing. And I'm grateful to my lords, my lord. I say, my lord, with the deepest of respect, that
They may be disqualified for
That's
whatever
right.
reasons, but
That's
they are
right.
not tainted.
Lord, I have nothing more to add, but only thing I say, because as your lordship, আমাকে দে,
No, that
2014 volume 6.
see that word was picked up by the tribunal, so it traveled throughout. But that word is in case where a proceeding is vitiated for some malpractice or large scale irregularity. That's not the case.
Now kindly see, I have placed before my lords. My lord, this was on the basis of the hints given by your lordships, my lord, while hearing out this batch of matters. 2014 volume 6 SCC 644. My lord, kindly come to paragraphs 32 to 36 and 40 to 48. Yeah. 2021 একদম লেটেস্ট।
Yes, we have seen it. Any particular paragraph you want to emphasize?
Well, I had relied upon paragraphs 32 to 36 and 40 to 48.
40 to 40?
42, 48, 40, 41, 42, 43, 44, 45, 46, 47, 48. Now the next judgment, this is the latest judgment. I started searching from 1980s. Now, then Millard, I find 2021, 2021, volume 4, 2021. Yes. 2021, volume 4 SCC, page 631. This is paragraphs 35 and 55.
Thirty-five and
35 and 55.
this citation I could not remember that day.
Yes, because this citation came up because of my lord's intervention, and then my lord, Mr. Justice Parthasarathi Chatterjee was searching the I cannot search it. I am really I am crippled. Therefore, I started searching, and his lordship had indicated in the court that I am giving you the judgment. We are learning every day from my lord's that if a person should acknowledge it and should make appropriate submission, because this is a two-way game, it's not a one-way game. I find it from page paragraphs 35 and 55. ওখানে গিয়ে কিছু এবং সেখানে কোনো স্পেসিফিক রিজন নেই। I submit to my lord's that having regard to the judgment which I should say, that there is an observation that, or this comment that this tainted and untainted category can be segregated. But apart from that, I should also disclose to my lords that I also found a judgment of the prior to 2014, because courts are laying down the views consistently. 2000 Para 35 of this judgment, 631, Miller, just a second. না 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 এটা পাতাটা বের করছি, প্যারাগ্রাফ 35। Your lordship is referring to paragraph
35.
oh,
You
35.
said
sorry.
35 and 55.
Yes.
So we are saying just read the first sentence of 35. In deciding this batch of SLPs,
Yes.
we need not reinvent the wheel.
Will.
So you said earlier judgments, therefore we said.
I did an unqualified apology before my lords. But I should draw it to the attention of the court. Do I just think take today? Yes, 2003, volume 7 SCC, 285, paragraph 6. On a careful consideration of the contentions on either side in the light of the material, including the relevant portions of the report said to have been submitted by the special committee constituted for the purpose of inquiring into the irregularities, if any, in the selection of candidates filed in our directions, which report itself seems to have been produced for the perusal of the High Court, there appears to be no scope for any legitimate grievance against the decision rendered by the High Court. There seems to be no serious grievance of any malpractice as such in the process of the written examination, either by the candidates or by those who actually conducted them. If the board itself decided to dictate the questions on a loudspeaker in English and Hindi, and none of the participants had any grievance in understanding them or answering them, there is no justification to surmise at a later stage that a time lapse in dictating them in a different language left no room or scope for the candidates to discuss among them the possible answer. The posting of invigilators for every 10 candidates would belie upon any such assumption. Even that apart, the special committee constituted does not appear to have condemned that part of the selection process relating to conduct of the whole examination itself, except noticing certain infirmities only in the matter of evaluation of the answer sheets with reference to correct answers and allotment of marks to answer some of the questions. In addition thereto, it appears that the special committee has extensively scrutinized and reviewed the situation by reevaluating the answer scripts of all 134 candidates as well as 184 unsuccessful candidates, ultimately found that except 31 candidates found to have been declared successful, though they were not really entitled to be so declared successful and selected for appointment, there was no infirmity whatsoever in the selection of the other successful candidates than the 31 identified by the special committee. In the light of the above and in the absence of any specific or categorical finding supported by any concrete and relevant material, that widespread infirmities of all pervasive nature would be really said to have undermined the very process itself in its entirety or as a whole, and it was impossible to weed out the beneficiaries of one or other irregularities or illegality, if any. If any, there are hardly any justification in law to deny appointment to the other selected candidates whose selections were not found to be in any manner vitiated for any one reason. Against applying a unilateral, rigid and arbitrary standard to cancel the entirety of the selection, despite the firm and positive information that except 31 of such selected candidates, no infirmity could be found with reference to others, is nothing but total disregard of the relevancies and allowing to be carried away by irrelevancies, giving a complete go-by to contextual consideration, throwing to the winds the principle of proportionality in going further, and that was strictly and reasonably to meet the situation. In short, the competent authority completely misdirected itself in taking out such an extreme and unreasonable decision of cancelling the entire selection, wholly unwarranted and unnecessary, even on factual situation found true and total in excess of the nature and gravity of what was at stake, thereby virtually rendering such a decision to be irrational. We do not find any infirmity. Now, my lord, I just submit to my lords what I could find out in my reading. In the first list, my name appears. In the second list, significantly, my lord, there is no reason. And which is of 2021. Income. That's right. Can it be a matter of a, and kindly see, my lord, I say this thing with a heavy heart, that while reading this judgment of the, which I had indicated and which I searched after my lord, had put an expression in the court that there is a recent judgment of 2021 volume 4 SCC 631, that this principle could have been also applied. Though this is an extrajudicial matter, kindly do not take me amiss. In a recent recent batch of matters before the Supreme Court in respect of the School Service Commission. No, though that's the reason I said that it's an extrajudicial matter. But it cannot be a fact. It is admittedly, Millard, I also appeared in that matter. But at one stage, I just told the clients, kindly do not engage me in this matter, because so far as my clients are concerned, I do not find that there is rationality or reasonability insofar as giving him appointment is concerned. There I made this subject, and I just declined myself, Millard, to appear further. But in these hard days of economic ruination, and Millard, the doctrine of comparative hardships, lordships are also thinking, because there is no employment. And now kindly consider, Millard, that if they, I said tainted candidates, exclude them. There should not be any window open for them.
None of them are.
None of them. And after noticing it, my lords was pleased to make this comment. Yes. That then would have been different. Yes, yes, yes.
To maintain uniformity in the selection process, there is no scope to condone these lapses which they have committed, and therefore they have to go.
It's absolutely, we stand in a different platform. I now, Millard, leave it to the gracious consideration or magnanimity of the court. I cannot say anything more. Because going into the...
is correct. Question whether they can be termed as
No, but this incomplete thing, I was just going through the records cursorily, somehow I found that it is, by according to them, it is a very important thing, because this declaration is to be given in handwriting in a particular ink, and that only aids in the process of determining whether an imposter has sat in the place of the person or he has himself sat. So it appears to be, in the way it has been stated in the chart, as a very innocuous kind of a thing, but it is a procedure which they have in the advertisement said that if you don't comply your exam, you will not be evaluated. So whether tainted or untainted, that so, but then we wonder how your name figured in the earlier list.
This is what I was going to submit, that they had relaxed it. In my own suppose, the gravity of that particular mistake was not of that magnitude that they would have been.
Is there a scope to condone this under the rules, under the advertisement? Is there any provision, or is the advertisement very clear that in case of such violation you will not be evaluated and you will be disqualified?
At the gravity of this error being of such a big magnitude, they would not have put my name in the first place.
We don't know. See that first list. That is why the court said that something has to be done. It cannot be sustained.
We took a different route altogether where they categorized.
So that list was, see the expression which has been used may not be very.
There was no malpractice. There's no finding to the effect of any malpractice.
You please read paragraph 8.1, 8.2 and 8.3 of the vigilance report. Somewhere around page 129 maybe.
29.
8.1, 8.2 and 8.3.
Point
4 also.
of the vigilance report, Lordship, that gives out. It's a page number 130, 8.3, it starts from page 129. এটা দেখুন। না না এই তো এখানে আছে 8.1, 8.2
The one significant feature I found in the advertisement at page 41, that the Chief Postmaster General, West Bengal, Kolkata, reserves the right either to cancel the recruitment fully or partially if any irregularity in the conduct of examination or selection is noticed.
Page 42.
Page, this is in my brief, this is 40. The 41 কি বলবো বলতে নিয়ে জজের কাছে
47.
Milord,
There
it
is
is a-
overwriting in the
and
page.
excuse me, Milord, I am just page 47. Page 47, no, page এটা কি 47 কোথায়? 47.
49 তো।
Important
47.
important information. Important information.
Yes, important. I'm good. The Chief Postmaster General, as my lord got it, Milord.
Yes, please.
West Bengal Circle, Kolkata reserves the right either to cancel the recruitment fully or partially if any irregularity in conduct of examination or selection is noticed. Decision of the Chief Postmaster General, West Bengal, is in respect of all matters pertaining to the recruitment test would be final and binding on all the applicants or candidates. The vacancies notified are likely to change. Registration by an applicant is purely provisional. Only after scrutiny of his or her application, her educational qualification and other eligibility condition or her eligibility as an eligible candidate shall be decided as per the requirement notified in the notification advertised.
So he
If a candidate is found ineligible at a later stage, this is very important, of the selection process, his or her candidature will be summarily rejected and fee shall not be refunded. Therefore, you cannot categorize me as a tainted candidate. My candidature can be cancelled. Supposing I have not filled up the form, I have not done the required things which are required to be done in a particular manner, then you could have done it because terms and conditions have crystallized my rights.
His notification point packages that 8.3 as well as the নিয়ে শিক্ষা ব্যবস্থা ওদের হাতে বাহান্নটা দিন এই ডকুমেন্ট করেছিল তার মধ্যে ওরা কোনো প্র্যাকটিস করেনি আর
এটা কত পাতায় আছে?
এটা হচ্ছে পেজ 136
পেজ 136 ও যা পেজে ইয়ে হতা মানে
0.3 তে আছে
Lordship,
বইতে তো মিলবে না।
এই পয়েন্টটা দেখো তাহলে আসবে সেটাও মিলবে না যাবে একদম
বলবো বল মানে
এটাই আসো 8.3
130
হ্যাঁ।
কি আছে?
8.3
কিছু brief এভাবে answer করে দিস কেন বাবু? এভাবে তো মানে
malpractice হতে পারে।
he was my learned friend below. Just I indicate to my lord. Maybe that my page may not
130.
tally. Page
130.
130. Kindly see. My learned friend Milord wants to Milord indicate to my lord that there was a period of 52 working days in their hand. Kindly see this paragraph, page 130, paragraph 8.3.
Yes, I have just pointed out.
I have nothing more to say. I close my brief. I close my brief because Lordship had taken note of everything. This Milord, I say, kindly have some because I was looking into the matter from all sides, and
But in spite of 8.3, the High Court has passed an order and that exercise has already been undertaken. Now we cannot turn the clock
And
back.
the-
Therefore, we are asking you, was there any provision that it could be overlooked or relaxed? There is no provision.
সেটা জোসেফ যেটা করবেন।
Then we will ask, call upon.
Yes. And the inherent jurisdiction of the court does not take away the right. Inherent jurisdiction of the court under Article 226 does not.
Therefore, we are saying, what is the effect of the
That's
lapse
right.
committed by you?
Yes.
That's why we are asking, where is the requirement
Yes.
in the advertisement of making a disclosure and what is the effect of non-disclosure?
And how I am being categorized as a tainted category candidate.
That of course.
That becomes the future disqualification also. Kindly view the matter from a particular angle also, that I appear in an examination. Then I am being Milord categorized as a tainted candidate. Will it not be a future disqualification? Many of the candidates have a particular Milord.
No order saying that you are tainted. That will not stand against you.
So I say that.
Insofar as the 9 candidates of the petition and CM number 50 is concerned, most of the reasons are the certain questions are dotted. Or 2, it is you have used whitener, and for 2 it's you have erased some.
So therefore, we want to see which rule, which procedure you have offended by doing so.
Yes.
We can be.
Kindly pass an order. Otherwise, Milord, the railway, the particular departmental authority, because in my kindly do not take me amiss. Milord, my very little experience of 35 years, Milord, gives me this thing, gives impression in my mind that unless there is an order from the court, even if there is an order from the court, there will be 100 defenses. But however, if there is an order of the court, at least they will try to find out. Otherwise, no instructions will be coming to the court.
Lordship will kindly come to the vigilance investigation report.
Yes.
Come to page 123, paragraph 3.4. That is the petitioners in item number 14, Lordship. And this is the case of incomplete declaration. Candidates who furnished incorrect and incomplete declaration are to be disqualified as per one of the conditions of the recruitment clause by preamble para of OMR sheets under heading important instruction for marking response on OMR answer sheets, which reads as strict compliance of instruction is essential. OMR sheets will be processed by electronic means in computer. Invalidation of answer sheet due to incomplete and incorrect filling of OMR sheet will be the sole responsibility of the candidate. It reveals that several candidates who defaulted in the clause were still declared successful by the agency. So this is where, Lordship, these are the tribunal has also observed that these sheets ought not to have been evaluated at all. Therefore, maybe there are sheets with similar defects which have not been evaluated. And here, some of the sheets have been evaluated, Lordship. Lordship,
No,
if your
they-
Lordship,
the allegation against the petitioners of the writ petition is incomplete declaration.
yes, Lordship, this is incomplete declaration. The candidates who furnished incorrect and incomplete
Are
declaration
to be disqualified.
are to be disqualified.
Does it make me a
So where is this stipulation?
Lordship, it appears in the OMR sheets.
So where is that?
I'll
That's why
just-
we are asking. See, it should have been,
I'll
it
just
forms part of the vigilance report, because if you come to the next
Yes,
page,
Annexures, and
at the next page,
Actually-
4.2a, annexure E, capital Roman 3, it should have been a part of this.
right. Lordship, Lordship, my learned friend in item number 21 has appeared and
For the respondent.
for the respondent. So this is an OMR sheet, Lordship, I think. আরেকটা হবে? আরেকটা দিন না? এটা OMR sheet. Lordship, this is so Lordship, strict compliance of instruction is Lordship in the reverse. The reverse, Lordship. Use black or blue ballpoint pen marking the circle or any other color. Please fill your roll number, registration, question booklet, so and so. Once a circle is darkened as answer to that, the question is final. No change by erasing, using fluid, or marking cross in the circle is permitted. Lordship, that is also a case in the second one. The marking should be dark to cover the circle completely so that the letter A, B, C, or D, as the case may be, inside the circle is not visible. The use of calculator, mobile phones are strictly written. Multiple answers given against one question will not be considered. Do not fold, cut, mutilate, or any stray. Do not do any rough work. There are 100 objective type questions, out of which 25 questions each for part A, part B, part C1, and part C2 in the question.
So we are concerned with 3 in your case.
Lordship,
You have
3.
got a copy?
No, he's got the instructions.
No,
Once
unless you
circle
give them
is
a copy, I
darkened.
will not consider.
Lordship, then I've taken it from, he'll be requiring it for item number 21. So if your Lordship then I'll have to furnish copies. This is
You give us copies, we can Xerox copies.
that we can, Lordship. This is the instructions for item 21 actually.
Because in your case, the issue is of eraser and fluid. So you are covered by 3 and
Lordship,
so that
then
is
I
covered
can-
by 3.
Lordship, then I can get their OMR sheets. Then I should,
Their OMR sheet is not required.
the
They have come to a correct finding or not has to be
correct is Lordship, my
That
case is
we will not like to go into.
Piece of taint there.
that's right.
That we would not like to go into.
Oh, Lordship, actually, Lordship,
That would be
pausing for
traveling a bit
moment.
too far.
Lordship, these are all
Whether they have
Lordship,
8.3.
8.3, whether they have done it or
But that is over now.
that
All that is over because it has gone through a scrutiny up to the High Court. High Court said you
segregate.
take a segregating exercise. Now they have done it. So
Lordship,
after this exercise, these lapses have been found.
Lordship, I don't think I can help my learned friend because if it's a Xerox copy,
So you are
That-
covered by 3 and the other writ petitioners are probably covered
the
by what is stated
declaration.
at the top
yes,
in bold letters.
that is the problem. Now this set has been evaluated.
And this is what they
Maybe
have not declared.
Maybe they have been that they have not.
Yes. See, that's why I was saying this is a standard format in your OMRs nowadays because it ascertains that the candidate has sat in the exam. Because that handwriting can be tallied at if there is an issue, if it arises. So non-submission of this declaration or incomplete,
That
it
The candidates. Not to taint it. My, as far as we are concerned, it's not their case that
Let them place this on record. Let them place this on record.
Lordship, these sheets are the photocopies.
No, no.
Xerox copies.
The annexure, if you give us the annexure to the vigilance report, that will suffice.
Lordship, then I'll get it. Then
Because what they have said before the tribunal is that there was no occasion to re-examine the marks. That was their stand. They have not said that I have not done this, I have not done that. So let us see what the annexure says.
that's right. Lordship, absolutely. Lordship.
Let them not take a
Lordship,
state motherly attitude. This is absolutely,
that is it, Lordship.
this is absolutely a state motherly attitude.
While segregating, this is what we.
The
Lordship will kindly.
learned advocate.